You're listening to the Cyberwire Network, powered by N2K.
This episode is brought to you by Focus Features. On March 27th, Focus Features invites you to be a part of the most explosive movie of this year's Sundance and South by Southwest film festivals. The AI doc, or How I Became an Apocalyptimist, is being called supremely entertaining and the most urgent movie of our time. The AI doc, or How I Became an Apocalyptimist, rated PG-13, only in theaters March 27th.
Hello, everyone, and welcome to Caveat, N2K Cyberwire's privacy, surveillance, law, and policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen from the University of Maryland Center for Cyber Health and Hazard Strategies. Hey there, Ben.
Hello, Dave.
On today's show, Ben has the story of another legislative battle on reauthorizing Section 702. I got the latest on a New York state bill aiming to restrict the use of AI chatbots when it comes to matters that traditionally require licensed professionals. While this show covers legal topics and Ben is a lawyer, views expressed do not constitute legal advice. For official advice on any of the topics we cover, please contact your attorney. Ever wished you could rebuild your network from scratch to make it more secure, scalable, and simple? Meet Meter, the company reimagining enterprise networking from the ground up. Meter builds full-stack, zero-trust networks, including hardware, firmware, and software, all designed to work seamlessly together. The result? Fast, reliable, and secure connectivity without the constant patching, vendor juggling, or hidden costs. From wired and wireless to routing, switching, firewalls, DNS security, and VPN, every layer is integrated and continuously protected in one unified platform. And since it's delivered as one predictable monthly service, you skip the heavy capital costs and endless upgrade cycles. Meter even buys back your old infrastructure to make switching effortless. Transform complexity into simplicity and give your team time to focus on what really matters, helping your business and customers thrive. Learn more and book your demo at meter.com/cyberwire. That's METER.com/cyberwire. All right, Ben, we got a lot to cover here today. You want to kick things off for us?
Sure. So first I'll acknowledge, Dave, this is our 300th episode.
300. Hard to believe.
A cause for celebration. It's been quite a fun run, and here's to 300 more.
So that's about 6 years, I guess, right?
It is, and yeah. I've loved every minute of it. So,
well, likewise. Thank you for taking the time. It's been a pleasure, and I look forward to what's yet to come.
And thanks to our very loyal listeners. And unfortunately for our listeners, you're going to hear me talk about a topic that we've covered ad nauseum over the years. But
way to sell it, Ben.
It is still very unsettled. So you might remember Section 702 of the FISA Amendments Act of 2008. Which is a surveillance law. It authorizes the electronic surveillance of non-U.S. persons located outside of the United States, but mostly it's controversial because of incidental collection of U.S. persons' communications. So if I'm communicating with an overseas target, that goes into a database. Government can search the database without a warrant. The last time this was reauthorized was all the way back in April 2024. And because there was some disagreement among lawmakers about the future direction of the program, they only reauthorized it for 2 years. And just checked my calendar, and that would be next month that the authority is going to expire.
Right.
And frankly, I don't know how this is going to be reauthorized. It always is, and I assume it will happen this time. But there are just so many potential roadblocks here that I think it's worth covering.
All right, well, let's dig in here. What's going on?
So Wired had an article about an amendment, a bipartisan amendment being proposed in both the House and the Senate that would institute a warrant requirement in most circumstances for the government to access U.S. persons' communications in the 702 database. Sponsored by Mike Lee, conservative Republican in the Senate, and our friend of the show, in theory, I guess, Senator Ron Wyden.
The usual suspect, Ron Wyden.
Usual suspect. And then in the House, it's Republican Warren Davidson and Democrat Zoe Lofgren. The idea here is Congress has attempted many times to institute this warrant requirement. The executive branch under both Democratic and Republican administrations say that this would be too onerous. Not only would it hurt our intelligence capabilities, but it would hurt our law enforcement capabilities. Because it's very convenient for federal law enforcement agencies to be able to look through this database without going through what they see as kind of a disjointed and cumbersome warrant process.
Right.
So this actually failed by one single vote in the House the last time this was being reauthorized. And the Biden administration had to do some lobbying to get some Democratic members to vote against it. I think there is bipartisan support for this idea, and I think there is increased momentum behind this idea because of AI. And the reason I mention AI is in the pre-AI days, you have this giant database, and searching through the database would take some effort. You have analysts who go through it. It's not like it works slowly, but it's a lot of records to comb through.
Yeah.
And it's relatively labor intensive. AI changes the game. If you have a good prompt and you want information on a U.S. person, it's going to be much easier to find. If I wanted to develop a full dossier on my political enemies, I would not have to hire Christopher Steele. If I have access to this database, which federal law enforcement agencies do, I could simply have an LLM do it for me. And I think that's one of the major reasons why there's such a push for this amendment. Trump administration is against the amendment. FBI Director Kash Patel, who previously supported it, at least somewhat, I guess, in 2024, has said that the FBI is against it. So we'll have to wait to see if that amendment passes. And then if it passes, is that going to tank the broader reauthorization effort of 702?
Right.
So that's one complication. To make things worse, this is a must-pass piece of legislation, and you know what happens with must-pass pieces of legislation. Everybody wants to get on the gravy train, right?
Right. So they graft things onto it, basically.
Exactly.
Yeah.
So there are some Republican members of the House of Representatives who are murmuring about including the so-called Save America Act to FISA reauthorization.
Really?
Yes. It is not germane at all to FISA reauthorization. This is a bill that would institute a voter ID requirement for in-person voting and for mail-in voting, and then also you'd have to prove your citizenship when registering to vote. And so without getting into the merits of that bill, it would be a poison pill for FISA because FISA is going to need Democratic support. No Democrat is going to support reauthorization if the Save America Act is included. It can't pass by itself because it doesn't have a filibuster-proof majority in the Senate. So this would be kind of an end-around way. But I don't think Democrats would play ball. They'd say, we're not voting for a FISA reauthorization until you remove this poison pill.
Right.
And then the other complication is the Department of Homeland Security is still shut down. And we need to reopen that. So that whole effort to reopen DHS and also institute whatever reforms Democrats are requesting for immigration enforcement, that might end up being grafted onto this effort as well. So it's going to be a wild month in April to see if this is reauthorized.
What are the various ways you can imagine this playing out?
So I could imagine the authority at least temporarily expiring. The reason I say I can only imagine it temporarily expiring is this is the crown jewel of our intelligence apparatus. Presidential administrations of both parties have said so. Ultimately, we are in an enhanced threat environment right now.
Yeah.
With given what's happening in Iran. So I just don't see long-term members of Congress failing to reauthorize this authority. One thing I will say is you have to get annual reauthorization from the FISA court to run the Section 702 program. I believe, and I don't know this for sure because there's proceedings are secret, but I think it's very possible that the FISA court will reauthorize Section 702 collection for another year. Therefore, that would put off the need to reauthorize the legislation, if that makes sense.
It does not.
Okay, let's see.
Help me understand. Who has the ultimate authority here?
So all the FISA court can do is authorize the program that exists in law. So the law describes the parameters of the program. It says that the FISA court has to look over all the details and authorize it, and it can authorize it for up to a year.
Okay.
I don't know for sure, I believe that the FISA court has recently done that, and that would authorize Section 702 as is written in the current legislation through early 2027. Now, when we get to early 2027, that's where the roadblock would happen because there would no longer be a statute authorizing the FISA court to approve 702 targeting procedures.
So we got ourselves a loophole.
It's a bit of a loophole. It's a very, very uncertain loophole.
Okay.
Because you could see, let's say a criminal gets charged and the evidence is derived from a Section 702 search that took place after the legislative authorization had lapsed. There are going to be all types of legal challenges saying, well, just because the FISA court reauthorized it for a year, it doesn't mean the broader program was blah, 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 reauthorized.
I see. Yeah.
So that creates a level of uncertainty as well. I can't envision a future where the administration accepts the warrant requirement. Maybe there's some type of compromise they can come up with. They've tried that in the past, and most of the compromises have just been, I think, poorly drafted. Back in 2018, during the last reauthorization, they came up with a provision that a warrant is only required for certain domestic crimes, and there are a bunch of exceptions for the most violent crimes, murder, sexual assault, etc. I don't think that actually really fixed anything because the exceptions kind of swallowed up the rule. So they might try and do something like that, some type of compromise, workaround that preserves the warrantless database, but also gives some sort of nod to civil liberties advocates who've complained for a long time that this is an avenue for backdoor searches.
Is there any chance that there could be a completely fresh look at this, or are we kind of stuck in this treadmill of nipping around the edges of 702?
I think we're stuck in the treadmill for a couple of reasons. There were actual efforts to reform this the last time reauthorization was up, not just relating to the warrant requirement, but on some other provisions as well. Some of them ended up being included in the last reauthorization, things like transparency requirements, and those have made a difference, especially within the FBI, who has really tightened up its targeting procedures. And at least under the previous director, Christopher Wray, had said that they'd cleaned up their processes to stop the inadvertent collection of U.S. persons' communications. But they just haven't gone through that process this time. They haven't gone through like a committee markup. There's no, as far as I'm aware, comprehensive FISA reauthorization bill that's had like full House and Senate committee hearings. And we're approaching April. So this is going to kind of have to come together in a haphazard way. I think there are a lot of reasons that that's happened. Attention has been diverted elsewhere to immigration matters, to DHS, to the Save America Act, to everything else that's going on in the news, that I think the attention span for members of Congress has been elsewhere. So it would be nice if we could like really review this lock, stock, and barrel and come up with a comprehensive reform proposal that balances civil liberties needs with national security needs. And maybe we will do that eventually, but I think for that to happen, we'd have to extend the current authority for a few months while we work out the details, because I think the clock is running out.
Yeah. So for the moment, it seems as though we're kicking that can down the road.
Probably, yeah. And that's another outcome I could foresee. So we get to the end of April, nothing's happening. Perhaps there is an agreement to extend the authority through July, and then we'll see what happens in July. They've done that in the past. That happened at the end of calendar year 2023, where a lot of other stuff was going on. FISA was set to expire, and they said, let's punt this off to April, and they were able to get it done that April. So we shall see. There's a lot of uncertainty here, and the fate of this program is certainly up in the air at this point.
How hot are the disagreements from the two sides here? In other words, Are these sort of, fundamentally dig in sort of things, or are they collegial disagreements?
They're more collegial than you would expect, partially because this isn't a polarized issue.
Mm.
You have a lot of civil libertarian-minded Republicans who've been longtime skeptics of Section 702 and are very reform-minded on this and have been willing to work with super liberal Democrats to achieve legislative changes here. And we see that with this proposed warrant requirement amendment. Conversely, you have very national security-minded Democrats. Chuck Schumer, their leader in the Senate, is one of them, who are defenders of Section 702 and want to see it reauthorized. So it kind of jumbles the coalition a little bit. Certainly there are strong disagreements here, but it's not like immigration or or abortion or some other hot button issue where it's like divided 50-50 and nearly perfectly aligns with party affiliation. That's not what we have here.
Yeah.
It's people who have genuine disagreements on the balance between having this valuable intelligence tool and protecting civil liberties.
Is it wonky enough that that we don't see a lot of stump speeches about it?
It is, but for the people who do care about it, it rises to the level of an obsession.
Huh.
So Ron Wyden, he probably writes letters on Section 702 at least every month. That might not be an exaggeration. A letter to the administration about something he's heard that he can't disclose publicly about an abuse in the program or an idea for reform. He mentioned something in the article we're going to post in our show notes, covers it, where he says 702 needs to be reformed. There needs to be a warrant requirement. I can't really divulge the full details, but something that I've seen further indicates the need for a warrant requirement so that this authority is not being abused. So we don't know what that is. I mean, there
it's
have
hard
been
to contend with, right?
Yeah, there have been abuses in the past. The abuses have been bipartisan. They have used the Section 702 database to look into Black Lives Matter protesters and January 6 protesters. And I understand people having a problem with it. This is supposed to be a foreign intelligence tool. And when we use our intelligence services within the United States, we expect to be protected by the Fourth Amendment's prohibition on warrantless, unreasonable searches and seizures.
Yeah.
And when we lose that expectation, I understand people getting angry about it.
You can understand how it's irresistible for law enforcement, though. I mean, what a powerful tool.
It's very powerful. And they will come and testify and say, we need this. The director of national intelligence right now is Tulsi Gabbard. She has been a critic of this in the past. It came up at her confirmation hearings, but now she's towing the line and agrees that this needs to be reauthorized. So once you get into that position of power, you realize how critical it is to protect our national security.
We'll be right back. AI is changing how enterprises operate and how they stay protected. It's time to eliminate risk and protect innovation. From March 23rd through the 26th, join Trend AI for actionable AI security insights. Catch impactful sessions at RSAC, then unwind and grab a bite at their lounge in Trapesueño. Experience industry-leading AI security in person, engage with the experts, and get your chance to win $500,000. San Francisco, let's AI fearlessly. Learn more at trendmicro.com/RSA. My story this week comes from the folks over at Bitdefender. Interesting blog post here. It's titled, AI Isn't Your Lawyer or Doctor. New York lawmakers say it's time to draw the line. And basically what this comes down to, Ben, is we've got State Senator Kristen Gonzalez, who's looking to amend New York's general business law to prohibit AI chatbots from providing substantive responses, information, or advice that would replace the services of a licensed profession. In other words, if you are anything that requires a license. So obviously a doctor, a lawyer, but I imagine also an electrician, a plumber,
dentist,
a dentist, right? Any of these sorts of things.
A hairstylist in some states
yeah, sure.
requires a license. Yep.
Right. It would bar chatbots from mimicking the actions of licensed professionals. So things like diagnosing health conditions or drafting legal documents, all those sorts of things would be prohibited. What do you make of this, Ben?
So I fully understand the intention here. We've worked on chatbot legislation in Maryland because I do think chatbots require regulation. We've covered some of the most serious incidents where they've supported things like suicidal ideation, and there have been lawsuits on that. I think this particular law is overbroad, and I think it's a bad idea, to be honest. First of all, a lot of us have been looking up basic health information about our illnesses, not on chatbots, but on Google for a long time, with the full understanding that it's not the equivalent advice that we are receiving from our doctors, but it is, for the most part, more helpful than nothing. LLMs are better than traditional Google searches, and I found, at least, that it's provided pretty useful information when I have the sniffles and I'm curious, like, what's going around this time of year, and what's a good medication, over-the-counter medication for this symptom. It's very convenient. I have the full understanding that that's not advice coming from a doctor, and I also would fully support a law that had required disclaimers that said, I'm not a doctor, but happy to provide this information.
Right.
But prohibiting it from giving any advice whatsoever, I think is overbroad. I think it brings up free speech concerns on the part of the developers and the deployers of these chatbots. When you have things like mandatory disclosures, that has its own free speech concerns, because in that case, it's compelled speech where you're forcing the chatbot and therefore its developers to say something, which the Supreme Court kind of frowns upon. So it runs into those constitutional problems. And I just think, while the effort is laudable, I just think it goes too far. I think we should leverage the good aspects of chatbots and LLMs in providing us useful information in the middle of the night when we can't sleep, and when we don't want to bother our doctor, or we don't want to go to urgent care, or if it's like, here's what happened to me. I got into a car accident. Do you think I would have a good legal case? Like, that's helpful background research. I think the average person would fully understand, as we say in the disclaimer for our show, that does not constitute official legal advice. You shouldn't use it in court. But just shutting people off from that information entirely, I think, takes things too far, in my opinion.
So it can help provide a filter for whether or not people actually take the time to engage with a true professional, which could save everyone time. Right?
Exactly. And it can inform people on the basics that otherwise their doctor and their lawyer or whomever other licensed professional would have to explain. And I think it could end up being beneficial to actual licensed professionals, because I'm sure people go to doctors and dentists all the time for things that could have been answered by an LLM. Now, again, fully need that transparency. People need to know that it's not official medical advice, that this person isn't your doctor. They don't know your full medical history, although you're sure welcome to reveal your full medical history
right,
on ChatGPT.
In that direction,
I think having those transparency requirements is one thing, but just preventing people from being able to do background research. And then it's like, well, what counts as a chatbot? Because Google Gemini shows up in a Google search. You know, if you Google, like, what do these symptoms mean? And Gemini responds, is that a chatbot? Does that qualify under the law?
Yeah. What about just going to, like you said at the outset, to WebMD, or looking something up in a book, right?
Exactly. And And I know that there are unique dangers to chatbots that didn't exist in a book. A book was edited by humans, presumably,
Right.
and you always run the risk of hallucinations or false information. But there are risks inherent in everything. And as long as consenting adults are aware of those risks, I think the positives just outweigh the negatives to me.
Hmm. I wonder how they would enforce this too. Just, there's so many different levels of chatbots. I mean, you can have chatbots that are locally run, that they're self-contained on your computer. How are they going to extend the long arm of the law to that? And
Right.
also on a state-by-state basis.
Or I was thinking about like TurboTax, for example.
Hmm.
Let's say it's giving an advice that technically only in New York state law, that's advice that can only be given by a CPA. This is just an example.
Yeah.
But like, does that qualify because that person requires a license? So if I'm like texting my TurboTax chatbot, am I allowed to take this deduction? And in New York state law, like a CPA is required to answer tax questions.
Mm-hmm.
Is that going to be illegal? Like, how far does this extend? I think there are real harms that the authors are trying to prevent here, but there are narrower ways of achieving those goals than the kind of blanket ban being proposed here.
Yeah. You could have some kind of a click-through disclaimer like, hey, I'm about to give you medical advice. We're all in agreement here.
Yeah.
Like
I am a chatbot.
A EULA for this advice, right? I'm a chatbot. I don't know what I'm talking about.
Yeah.
Use this medical information is for entertainment purposes only.
Right. And I think that would be completely appropriate. And you and I think most other people would understand that in context, where it's like, I know that if I'm searching, what does this symptom mean in ChatGPT? Like, I know that doesn't replace my doctor. And if those symptoms worsen, I will go see my actual doctor.
Yeah.
But just for an initial, like, hey, I'm kind of curious about what this might be. Like, that seems to me to be just very useful information that as long as there's that disclaimer, it's not harmful for us to have access to that information. And we should take advantage of the fact that we have this information at our fingertips. Put guardrails around it when we must, but don't nip it in the bud the way this bill proposes to do.
Suppose something like this made its way through. Could you see First Amendment challenges?
Definitely.
Yeah?
Yeah, I think it would run into major First Amendment problems. Even bills that do not go as far, but that seek to regulate chatbots have run into First Amendment issues just because of the First Amendment expression rights on the part of the developer. If there is a content-based restriction, which is what this is here, where it's restricting the LLM from specific content, then you run into strict scrutiny where the government has to have a really, really good reason to be enacting this law. And the means have to be narrowly tailored. I don't know how you could argue that the means are narrowly tailored here. I think there are a million other ways you could address the problem of chatbot abuse and suicidal ideation advice without instituting this full ban. Even if that is restricting this advice to minors and requiring some type of age verification. That would be another way of doing this that doesn't prevent adults from seeking out useful information online.
It makes me think, just sort of going up to a higher level, about how we've had these recent decisions that the output of chatbots, LLMs, are not eligible for copyright protection.
Mm-hmm.
So that makes me wonder, are they eligible for First Amendment protection?
I mean, most courts have held that they are. It's certainly it is a very unsettled question.
Mm-hmm.
I think if you are seeking to hold the developer or the deployer accountable in law, or you're seeking to require actions on the part of developers or deployers, then that does invoke free speech rights. It might seem like it's invoking the free speech rights of the chatbot, but really it implicates the developers and the deployers because it stops people from being able to do business in New York. And it does so by chilling people's rights of expression through their the chatbots that they've created.
Right.
And you can do that if you have a good reason to do it. And I think courts are going to be permissive. And certainly these are not unlimited free speech rights on the part of chatbots, but I think most courts have held that to a degree, chatbots, there are implied First Amendment implications to restricting chatbots.
Well, and I mean, I just keep thinking about that. In the same way that I'm allowed to go to a library in New York or a bookstore and buy some sort of medical guide, right? Or
maybe it's the medical guide lobby that's coming up with this.
Right, but in other words, I don't have to be a licensed doctor to read a medical textbook.
Let's take it another step. What about reading, your crazy great aunt on Facebook who's posting about chemtrails and how, all the things that vaccines cause.
Right.
And you take that advice. Like, I think a chatbot is far more trustworthy if it's correctly trained than some of the bad information one could receive on social media, for example.
Right. So the First Amendment protects misinformation.
It absolutely does. In most contexts.
Right.
And that's another reason why, even if the chatbot is giving out false information, that doesn't really lessen the First Amendment implications.
This is also messy, right? I guess because we're pioneering these things. This is uncharted territory and all that stuff. That
I think that's exactly what it is. Like, we're still trying to figure out how to resolve some very real problems, and states are taking creative approaches. There's a chatbot bill making its way potentially through the Maryland legislature that institutes regulations for that, at least as it relates to licensed individuals. That is more of a transparency requirement where it just has to reveal that it is not a licensed professional. I think you've seen that approach in other states, Colorado, I believe, being one of them. But I think we're just kind of experimenting here because it is a new problem. The problem is real. We've seen the deleterious effects of it. And some of these stories are heart-wrenching and gutting. And we don't want people to think that chatbots are actually their therapists, their doctors, or their attorneys.
Right.
But prohibiting them from any substantive advice, I think, is just a bridge too far, in my opinion.
Yeah. No, it's fascinating. All right. Well, we will have a link to all of our stories in the show notes. And of course, we'd love to hear from you. If there's something you'd like us to consider for the show, you can email us. It's caveat@n2k.com. When cyber threats strike, minutes matter. Booz Allen brings the same battle-tested expertise trusted to protect national security to defend today's leading global organizations. They safeguard their data, strengthen enterprise resilience, and mobilize in minutes across energy, healthcare, financial services, and manufacturing. Their teams don't just respond, they anticipate, outthink, and stay ahead of evolving threats. This is powerful protection for commercial leaders, only from Booz Allen. See how your organization can prepare today at boozallen.com/commercial. And that is Caveat, brought to you by N2K Cyberwire. We'd love to know what you think of this podcast. Your feedback ensures we deliver the insights that keep you a step ahead in the rapidly changing world of cybersecurity. If you like our show, please share a rating and review in your favorite podcast app. Please also fill out the survey in the show notes or send an email to caveat@n2k.com. This 300th episode is produced by Liz Stokes. Our executive producer is Jennifer Iben. The show is mixed by Trey Hester. Peter Kilpie is our publisher. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening. If you only attend one cybersecurity conference this year, make it RSAC 2026. It's happening March 23rd through the 26th in San Francisco, bringing together the global security community for 4 days of expert insights, hands-on learning, and real innovation. I'll say this plainly, I never miss this conference. The ideas and conversations stay with me all year. Join thousands of practitioners and leaders tackling today's toughest challenges and shaping what comes next. Register today at rsaconference.com/cyberwire26. I'll see you in San Francisco.
Been out here all morning. Not a single bite. Guess the fish finally figured it out. Just like hackers do, when Cisco Duo's on guard. With Duo's end-to-end phishing resistance, every login, every device, every user stays protected. No hooks, no catches, no bites. Cisco Duo. Phishing season is over. Learn more at duo.com.